Hello, my name is Tyler McClay. I'm the General Counsel for the Missouri Catholic Conference in Jefferson City, and we're going to be talking today about how abortion is in the federal health care bill that was passed by Congress back in March. There's been a lot of information out there about how abortion is included in the health bill, and I'm going to try to clarify some of the concerns that the U.S. Conference of Catholic Bishops have with the federal health care bill, and specifically the issue of abortion in the health care bill. So we're going to start by talking about the history, how we got here, how the abortion was dealt with prior to the legislation that was passed in March, and how it's dealt with in the bill itself. So we'll talk first about the history, then we're going to talk about the health care debate and the events leading up to the passage of the bill. We're going to look at the bill itself, and we're specifically going to look at the issues pertaining to abortion and conscience concerns that are part of the bill. We're going to look at President Obama's executive order and how it does and doesn't affect the abortion issue. We're going to look at what states are doing in response to the passage of the health care bill. And we're going to talk a little bit about what we can do to try to fix the health care bill from the perspective of being a citizen. So first, let's talk about the history. I think it's always important to go back and look at the events that led up to the passage of the bill and to understand the history of how abortion has been dealt with by the U.S. Congress throughout the years. I think it will help us give a context for the debate that took place on the bill, and also to help us understand exactly what the problems are with the bill itself. So any discussion of abortion obviously starts with the Roe versus Wade decision, which was a U.S. Supreme Court decision in 1973. And that decision held, obviously, that the Constitution guarantees a woman the right to have an abortion. In 1992, the Planned Parenthood versus Casey decision affirmed a woman's right to have an abortion, and it outlined some ways in which states can regulate abortion. It basically stands for the proposition that a state has the right to regulate abortion, but it may not impose an undue burden upon a woman and her right to have an abortion. So following the Roe versus Wade decision, the first thing that occurred was the passage of the Church Amendment. The Church Amendment is actually codified. It's part of the federal statutes now, and it provides conscience protection for healthcare providers and individuals who work in hospitals who do not wish to participate in abortion and or sterilization procedures. Once we had the Roe versus Wade in place and a woman had a right to an abortion, it was important then for physicians and nurses and other healthcare providers who didn't want to participate in those procedures to have the right not to do so. And so the Church Amendment addresses specifically some grants that were offered by the federal government to various programs. It's not all-encompassing, and so it's limited in its scope, but it does provide some conscience protection to individuals who refuse to participate in abortion procedures and in sterilization procedures. From 1973 to 1976, actually, we had Medicaid paying for 300,000 abortions per year. And you might ask yourself, well, how is that possible? Well, the Medicaid statutes define medical care to include family planning. And whenever the courts looked at this issue and had to address the question of what family planning means, the courts ruled that abortion must be included in family planning. And so they ruled, when they were challenged on this issue, when people challenged the Medicaid statutes, that because the language of the statute is vague and includes family planning, that family planning includes abortion, and therefore abortion must be covered. So it was in that context then that we had Henry Hyde in 1976 seek to have amended onto the Department of Health and Education and Welfare, which is now known as the Department of Health and Human Services, basically the Medicaid statutes. He offered an amendment to the appropriation bill, which is the bill that actually puts the money into the program, an amendment that stated that no federal dollars will be used for elective abortion or for insurance coverage, including elective abortion. And that was the Hyde Amendment, which we've all heard of. And so there was a challenge to the Hyde Amendment, and that ultimately went to the Supreme Court, and the final decision came down in 1980, and the case was called Harris versus McCrae. And the plaintiff in that case was a Medicaid patient. She challenged the Hyde Amendment and basically argued that she has a right to an abortion under Roe versus Wade, and therefore she also should have a right to have the government fund her abortion because otherwise she would not be able to afford it. And the Supreme Court ruled in that case that although a woman has a right to an abortion, she does not have the right to have the government pay for the abortion. And so this challenge to the Hyde Amendment was basically shut down by the Supreme Court. And so as a result, the Hyde Amendment has been added and attached to appropriation bills for the last 34 years. And the Hyde Amendment has enjoyed bipartisan support, hasn't been complete. There's been a good bit of controversy about the Hyde Amendment because some argue that it denies indigent patients the right to have an abortion. And so, but it has enjoyed support from both sides of the aisle and has been a part of the appropriation bills for the last 34 years. And in the Harris case, interestingly, one of the arguments that the plaintiff made in that case was that the Hyde Amendment actually tracks Catholic teaching, and specifically the decision mentions the Catholic Church. And the plaintiff's argument was that because the Hyde Amendment is consistent and mimics Catholic teaching, that it results in the government actually endorsing a religion and in violation of the First Amendment. And the Supreme Court rejected that argument. They said that just because the Hyde Amendment tracks Catholic teaching or other religious teaching, it does not represent an endorsement of religion, and it doesn't violate the First Amendment. So, but the Hyde Amendment has been added to those appropriation bills and has been basically the law of the land from 1976 until our most recent health care debate. We also had in 2004 David Weldon seeking to add an amendment to labor, health and human services, and education appropriations for conscience protection. He added an amendment that provided conscience protection for doctors, hospitals, and health plans that don't perform abortion. And basically what his amendment stated was that any entity that receives federal funds is not required to perform abortions, and they cannot discriminate against doctors or healthcare providers who perform or don't want to perform abortions or sterilization procedures and things of that nature. In 2006, the state of California challenged the Weldon Amendment, and California argued this. California had a law that stated that doctors in an emergency room setting were required to provide any life-saving medical treatment in that emergency setting. And they argued that the Weldon Amendment would interfere with their law that required doctors to provide emergency medical treatment, and they included abortion. And of course, they had no exception in their statute for abortion. So they challenged the Weldon Amendment, stating that this would prevent them from being able to enforce their statute. The court dismissed their case and found that they were not able to show, California was not able to show any harm. The Weldon Amendment didn't cause them any harm, and basically they didn't feel that the state of California had legal grounds to challenge Weldon, and so the case was basically dismissed on a technicality. The court really did not address the merits of the argument, but only ruled that California didn't have standing to bring the case. So the benefits of the Church, Hyde, and Weldon amendments are that they provide conscience protection to doctors and healthcare providers. They also establish that no federal dollars will be used for elective abortion or for insurance, including elective abortions. And of course, they have an exception for the life of the mother, rape, or incest in the most recent version of the Hyde Amendment specifically. And the Hyde Amendment over the years has evolved. It initially started out as just accepting abortions for the life of the mother, and they've added rape and incest in later versions of the Hyde Amendment. which basically means that federal dollars can be used to pay for abortions in the settings where the life of the mother is at risk or the mother is the victim of rape or incest. The limitations of the Church, Hyde, and Weldon amendments are that specifically Hyde and Weldon are amendments and they're not bills. And that means that each year they have to be reenacted. Each time there's an appropriation in that particular year, the amendment has to be added to the bill. And so as a result, specifically Hyde and Weldon are subject to legal and political challenges. We've seen both in the Hyde and the Weldon amendments there were legal challenges to those amendments, and they're also subject to political challenges throughout the years. As each year these bills come up, they have to be re-voted, reauthorized, and so it's not something that's in the law forever and ever. We can say these two amendments are, the law of the land, as it were. So let's talk about the healthcare debate in 2009 and 2010. As we know, the House bill that went through the House included the Stupak Amendment, and that was offered by Bart Stupak, a Democrat from Michigan. Stupak's amendment basically stated the same as the Hyde Amendment, that no federal dollars would be used for elective abortion or for any health plan that covers elective abortion. On the Senate side, we had the Nelson Amendment, which was offered by Ben Nelson, a Democrat from Nebraska. And Senator Nelson's amendment had the same restrictions which were included in the Stupak Amendment, and both of their amendments had the same exceptions that are included in the Hyde Amendment, that being life of the mother, rape, or incest. The House bill was passed with the Stupak Amendment on November 7th, 2009. The Senate bill, the healthcare bill, was passed, as you recall, on December 24th, 2009. It did not include the Nelson Amendment language, nor did it include any language similar to the Stupak Amendment. So we had two bills that were close, but they needed to be reconciled. They were not identical bills. Then in January, we had Scott Brown from Massachusetts, who took the seat that Senator Kennedy had previously held. And what that did was it prevented the Senate Democrats from being able to break a filibuster on debate. So what that meant was that the House bill was not going to be the vehicle that could get health care passed. And so, as you recall, the Senate bill then went to the House for passage. So before the vote on the final bill that was taken in the House, the USCCB issued a statement on March 20th in which it sent specifically a letter to the House, and it said that you need to fix the flaws in the Senate bill or vote no. And they stated that although they are in favor of health care reform, they said that health care reform must protect life and conscience, and they were basically stating to the House they need to fix the life and conscience problems that were in the bill before passing it. They also were pushing for universal coverage. They had some concerns about the bill, which excluded folks that are immigrants that had not yet obtained legal status in the U.S. from obtaining coverage through the health care bill, and those people that were here undocumented but living in the U.S., in some cases paying taxes. They felt that they needed to be offered provisions for being able to get coverage through the health care bill as well. So the House passed the Senate bill on March 21st, 2010. As you recall, that was a Sunday, and it was after Bart Stupak had met with the president and been offered the executive order that he agreed, and parts of his coalition agreed, to sign off on the bill. President Obama then signed the final bill on March 23rd, 2010, and the reconciliation bill, which brought the Senate and House bills together, was then passed on March 26, 2010.